Egan, and I am with Foley and Lardner's Marketing Department. On behalf of Foley, we would like to thank you for participating in our Market Regulation Series web conference. At this time, all participants are enabled in listen-only mode. Please note that in order to receive CLE credit, you must be both logged into the web conference on your computer and be a question and answer session at the end of the presentation. The operator will announce instructions for asking a question at that time. In the Files section of your screen, you will find a copy of the presentation slides and other documents that the presenter has made available. Participants must download the file titled NYNJ CLE Attorney Affirmation. A 5-digit class code will be announced during the presentation. You use that code to complete the form and then send it to me at kmegan@foley.com immediately following the presentation. My email address is also conference. Joe Edmondson. Joe, you may begin.
Thank you, Katie, and good afternoon, everybody. Good morning to those of you on the West Coast. Happy to have everybody here with us for the latest installment of Foley's Market Regulation Series, this one entitled SEC and FINRA Examination Priorities for 2013. For those of you who don't know me, I'm a partner in the Washington, D.C. office of Foley and Lardner. Richard, like me, focuses on representing securities broker-dealers, hedge funds, mutual funds, investment advisors, and so forth in SEC and FINRA investigations and disciplinary proceedings. Unlike me, Richard branch chief and attorney in the SEC's Division of Enforcement between 1990 and 1996. So Richard speaks to us today with the perspective of both a private attorney and as a regulator. So many of you may know the SEC and FINRA both communicate periodically with the industry. Are focusing on. The enforcement mission of FINRA and the SEC are by design public commissions. Not only do they publicize the filing, settlement, and adjudication of the cases so that's what we're going to be focusing on here today, is we're going to be looking at and dissecting what FINRA and the SEC have said that we should be looking forward out there in our in your firms and in our counseling practices. And I'm going to kick it off by sending it to Richard here, but first I'm going to go through the topics actually we're going to cover, so you have a roadmap of where we're going to go. And we encourage you to get your questions ready, because at the end we're going to save plenty of time to answer questions that you all have. We're going to talk on our understanding of what some of the senior officials at the SEC and FINRA have said that elaborate a little bit on those priorities. We're going to discuss the most commonly cited violations in FINRA disciplinary actions. We're going to talk about supervision and compliance, particularly the expanding role of and we're going to talk specifically about actions against compliance personnel. And then we're going to offer some practical guidance with regard to how policies and procedures should address some of these issues, and also how you might prepare yourself to best respond to inquiries from the regulators. And as I said, we'll leave time for questions.
FINRA started issuing a examination priorities letter, I don't know, 6 or 7 years ago, and at first it was just what the member regulation department was going to be doing, and after a year or two, market reg and enforcement jumped on, and then became sort of more inclusive. Marked change. The letter is much shorter and seems to be much more focused on sort of new items and things that they are, really seeing a change in emphasis on. So based on the letter and also on some comments, I sort of distilled the top things based on the, what came first and what's, given more space into 4 topics I'd like to cover today. Customers chasing yield, so one of the topics that came up repeatedly at the recent SIFMA Compliance and Legal conference in Arizona. The complex products comes up from time to time, both as its own topic and then when they're talking about supervision and disclosure. Conflicts of interest is not really covered in the letter, but it is something that was quite a bit of attention to that in the conference today. So the first topic I want to talk about is chasing yield. Joe, you want to talk about where this concept comes from?
Sure, and so this is a very market driven, right? So we're in an environment now for quite some time of itself, but the so-called safe investments, the yields have dropped so low. The yield on the certainly short-term fixed income paper and even out to the long term is very low. So in order for investors to to make any kind of reasonable return, they're chasing yield. They're looking for products that have higher returns. They're just not willing to take the 1.5% that they're lucky to get off of a safe investment. So in that environment, and let me just say that when we're talking about the safe investments, so we're not even talking about the interest itself not too long ago that you should be familiar with. But so what's FINRA's concern, Richard? Because if there's not something out there that people can invest in safely, don't they have to take some extra risk and chase some yield, or else they're going to be left with nothing? They're going to be dying.
Of the investments that brokers might be offering to their clients who are looking for higher yield. And they will be applying the provisions of the FINRA Rule 2111, which is relatively new. The same provisions as though they had been in effect. As the staff's position seems to be that 2111 is just a codification of long-standing interpretation. So they'll be looking for a reasonable basis suitability, that the firm made a determination that this product, or whatever it is that promises the higher yield, is suitable. Does this product match up with what is known about the customer, and do you have the information that is required for a comprehensive customer profile? My experience with customer-specific suitability is that in a lot of cases, firms start out selling sense. And then, as people get familiar with it, and the revenue to the firm or compensation to the associated persons gets known, that it starts drifting into pockets of people that may be less to the customers that really have a good fit for this. And then finally, there's the quantitative yield. How much of this product is appropriate for the individual investor? So those are the kind of things they'll be looking at. They'll also be looking at the disclosure. And as Joe So, they'll also be looking at, in this chasing yield concept, at what's told to the customer about, the impact of interest rates, which inevitably have to go up at some point, and how that would affect their bond portfolio, and how investors can prepare themselves as complex products.
Right. So before we start on that, Richard, what is a complex product? Is it anything that a regulator says that it is? Because I think the list that I've seen is quite comprehensive.
Well, in the 2000 products, high yield debt, structured products, ETFs, ETNs, exchange traded notes, closed-end mutual funds, and then the last two I really like, munis and variable annuities. So pretty much anything that has sort of option-like features I think would fall in this product. I think investments such as REITs that are just complicated because of the number of FINRA will be looking at is, again, suitability, just like in the yield chasing area, and then disclosure and supervision. And I think one key takeaway from this, and this came up repeatedly at SIFMA and is also in some of the other materials that FINRA puts out, is they will be looking at the training materials used by the firm to push this out to and this will impact a couple of areas. So it will be used to judge the suitability. So if the training materials don't alert the sales staff to the important features and risks of the product, they will assume that those features and risks were not understood when the suitability determination was made. Training materials will also be used be taken as a view of to what was actually said to customers in pitching these kind of materials. So it's very important to take a look at the training material through these lenses of how would a regulator look at this in terms of balance and suitability and other questions. One thing that we heard repeatedly at SIFMA was, can the sales force explain in one sentence making a real hard suitability determination for these complex products? So, can the sales force boil it down to one sentence?
And like so many things, I think you'll see a theme emerge here as we move on. So if the material is available and it's demonstrable what the representative was doing, what the firm was doing, that these issues were taken into consideration, vetted, and decisions were made, and you can document that. I think that what we've heard from FINRA over and over. Case where there is a lack of a demonstrable thesis for the investment or rationale for the investment, that's really going to raise the specter of enforcement.
Next topic I want to dwell on just briefly is conflicts of interest. As I said, this is not in the letter, but was repeatedly mentioned at the SIFMA conference. Compliance and regulatory problems. I don't think it's very useful in terms of setting it out as a priority, and that's because if you look at the literature on conflicts of interest and the cases that have been brought, conflict of interest is cited as being behind everything from churning and referrals. It's basically everywhere. So it's hard to sort of say, all right, they're going to be looking at this. What should I, focus on? One item that, is constantly sort of referred to as one of the key ways of dealing with conflicts of information is information barriers. Are they in place? Are they working? Or have exceptions or informal practices kind of swallowed up the information barrier? The other thing and that making sure that as conflicts are identified, that they're actually dealt with and resolved in one way or another, and that there's documentation to support what was done and that the issue was resolved. The next topic we'll turn to is, go ahead, Joe.
Yeah, I was going to say that we algorithms we as a firm have had experience with several investigations in this area. I think we've already learned some lessons that we can talk about. Obviously we've noticed that this area has attracted the broad interest of the regulators. We've seen inquiries from FINRA market regulation, FINRA acting on behalf of options markets. Exchanges, OC, and SEC enforcement all have weighed in on these issues of algorithms and high-frequency trading. So, in light of that, Richard, what are the key items that
only if you have algorithms or high-frequency trading as part of your business model, but if you're a clearing firm and your correspondents are engaged in this, or if you provide direct market access, these are things you might be concerned about. The first item that caught my mind or caught my attention electronic markets and automation and those kind of things. And at that roundtable, a lot of people brought up the idea of kill switches, and said this is an idea that the commission should consider. And then, in January, when FINRA's priority letter came out, there was the following sentence: in addition, we will focus on whether broker-dealers have firm-wide disconnect or, quote, kill switches, as well as procedures for responding to widespread system malfunctions. And to supervise the system, that the firm needs to have a way of shutting down its automated systems if things seem to be going awry. A couple of sort of practical points on this, as I've seen both as a regulator and advising clients, that it's really hard to pull the kill switch. You say, well, I think we're going to get this under control in just a minute. Maybe it's not as bad as it thinks. Maybe we can get by with with manual override. What factors are we going to consider, and take some lessons from other firms that have been there before you, and make it clear when and how you're going to use that functionality. The other one item I would consider is it's really important to have in place an alternative. So if you have to shut down your what I've seen is people wanting to pull a kill switch, but being worried that their customers are going to, the customer orders are going to be sort of orphaned. So these are issues to deal with. We've seen in SEC and FINRA examinations looking into Rule 15c3.5, the direct market access rule or sponsored access rule, that the investigation starts automated systems. So it gets to be a pretty widespread issue. Another issue that Joe's been thinking a lot about is FINRA and the SEC have been saying they want compliance and legal to get involved in the development of automated systems. Joe, you want to talk about that?
Sure. So the question is, you've got compliance and legal people who really don't know all that much, or it's the rare person who knows a lot about computer programming, IT, systems development, that sort of thing. On the other hand, what the traders want. In some cases, it's the programmers that basically are the conceptual minds behind some of these algorithms, and it's not even a situation where a trader is dictating what he wants or she wants and other. and you've got to have the programmers and the systems people understand what the rules require, and then you got to have the people that understand the rules, the compliance and legal folks, understand enough about the code and what it's designed to do in order to make a judgment as to, you know, and that necessarily means putting these people in the same room from time to time. Now, Tom Gira was asked very directly at SIFMA whether that means that legal and compliance has to attend every software development meeting, and he said quite plainly, no. You know, that's not the level that FINRA at least is. So, you know, that's not a lot to go on, but I think, you know, you start off with good communication and understanding, make sure the traders understand the rules, and make sure the compliance people understand the training. And then from there, perhaps you will have a
Thank you, Joe. A couple of just, you know, sort of checklist items that we've seen, they've mentioned, is they're looking for a pre-implementation testing of systems or, you know, algorithms. They're looking for firms to monitor changes after they go into production. They're looking at orders, marking the close or marking the open. And if you have, you know, wash sales or high volume that you know is not manipulative, they're going to be looking for, you know, supervisory procedures and efforts to verify that those, you know, classical badges of manipulation are not manipulative. Ignition. They're looking at symptoms of out-of-control automation. And these could be, you know, high volumes or, you know, what looks to be a loop, cancel and replace, cancel and replace. And we have seen them inquire in great detail about these signs of out-of-control automation, which were as brief as 1 second. You know, and get them looking at you. And, you know, the fact that you have not had an inquiry or a complaint from the market or the exchange, that's not an indication that this will not raise to the level of FINRA's interest. And finally, in the letter, they say that mini manipulation will be a major focus of inquiry this year. One of the things that sort of the sexy topic, the sort of topic that might, you know, generate a career enhancing disciplinary action is a confluence of events. You had the flash crash, which really, you know, got everyone's attention to, you know, how interdependent are all these exchange systems, and firms. You have the implementation of Rule 15c3.5, which imposes a whole regulatory framework around, you know, risk and regulatory compliance of automated systems. And I think, you know, the exchanges doing these kind of checks, you know, to bring out and drive home how important this rule is. Then you have the manipulation cases. All of these things point towards looking at trading systems and how they're supervised. And when you're on the receiving end of an inquiry by FINRA or the SEC that deals with these issues of automation and high-frequency trading and sponsored access, you need to look at it through that lens and say, this is these things very carefully, and they're going to judge any problems or any symptoms of automation gone awry or potential manipulation or badges of manipulation, as I like to call it, wash sales, etc., very skeptically and deal with it pretty harshly. So both and commitment to adopting the policies and procedures they're looking for and documenting that those things are a part of it. As Joe said, we've seen these inquiries from all sectors of FINRA and OC and enforcement at the SEC, and they are understanding of automation and algorithms and the nature of high-frequency trading, but that it is a little bit oversimplistic. They don't understand that the way one exchange works is a little bit different than the other, and the next one, which is next high-frequency firm, will be pretty similar. So, those are challenges for anyone, dealing with an inquiry on this topic. The next item that I wanted to talk about was compliance personnel. Taking a closer look at compliance personnel in any of those documents or in any speeches. But we hear the question asked repeatedly by compliance personnel. It's probably a reflection of recent cases, including the Urban case that the SEC handled, dealing with compliance personnel and their responsibilities. Or scrutiny of these people, but they are asking the question, has the compliance department taken on supervisory roles? And 10 or 15 years ago, it was pretty common to talk to compliance people and say, look, we surveil, we look, we help, but we have ultimately turned the responsibility for what to do with any violation or potential with the development of technology and automation of these systems, more and more, that model doesn't break down, and they're looking at, compliance and legal as the people who know what's going on with the automated systems, the people who may be directing responses. And so we're starting to see more questions and requests about compliance personnel to these issues. So while FINRA and the SEC will say that their basic stance has not changed. I think that compliance and personnel are getting more involved in what the regulators would consider supervisory roles, and that's putting compliance personnel more, in the substantive area of what
that a compliance person who is charged with reviewing exception reports with an eye toward bringing to the attention of the head trader or the head of the desk anything that appears to be out of the ordinary, that person can still claim that they are not involved in supervision for the sake of being a target of enforcement.
Things have changed a little bit. I left FINRA in 2008, and when I left, pretty much a standard procedure was if my group, the 20 attorneys in market regulation, wanted to do, and here's why. I think that that instance of taking the testimony of compliance people has become much more routine. So I think there has been a change or shift, and I'm not sure those explanations carry the weight they used to.
As long as the decision-making authority rested with the business person, that the compliance staff would be fairly immune, absent really terrible circumstances.
We've talked about two big trends here. One is the emphasis on algorithmic trading, and two, the expectation that compliance and legal will be involved in the development of algorithms and trading systems. And then, far side, and one deer saying the other, bummer of a birthmark, Hal. I think that compliance personnel need to recognize that they are going to be under intense scrutiny in these areas of supervising the development of trading systems and making sure that changes are a little bit now and move to some of the topics that are near and dear to OC. They put out their own national exam priorities statement, not a letter, but it's available to download on the files that we've provided. And it covers, examination priorities statement that deals with broker-dealers. So in 2013, and the OC statement is broken out into ongoing issues and emerging issues. From that statement, the staff intends to address certain trading risk areas with particular focus on high-frequency trading, algorithmic trading, proper controls around the use of technology, alternative trading systems, and order routing practices. So again, OC is involved in they have been very aggressive in looking at emails and gathering facts and sort of laying the groundwork for very robust investigations. And they are going to be has been gathering a lot of information, which they just call background. So they're investing the time to sort of get up to speed before they're even pursuing a specific case. They mentioned at unsuitable recommendations of higher yield products, e.g. municipal or corporate bonds. So, the idea of complex products and is a SRO rule, but the SEC is using that same concept to analyze sales of higher yield products. Expecting it to say, we're looking at valuations of derivatives and net capital and all that stuff, but no, this section talks about they're going to be looking at clearing firms
regarding clearing firms and correspondence. But we happen to have experience with one such case that came out of FINRA not too long ago, where we represented a clearing firm and to whom it extends credit. And if you let the correspondent trade without proper limits and, more importantly, a procedure to shut to settle a large quantity of trading that it might trades that it might not have the ability to get recourse from an undercapitalized correspondent. So I think that it's that kind of all different forms of trading, whether it be sponsored access, limits. I think the SEC has said very very clearly in various public statements that it's not going to necessarily second guess what debt, with some discussion and some consideration of the relevant factors, whether it's the creditworthiness of the entity that's ultimately responsible for the trades, but again, document the process by which the firm reaches a decision, and then the firm's in a better position to defend that when an examiner starts asking about it.
To making sure that firms have customer identification programs, customer due diligence programs, and sort of risk assessment processes in position in this area, that their anti-money laundering efforts are being scrutinized by Treasury and FinCEN and other regulators, and it's harder for them to there has been a failing in the anti-money laundering or suspicious activity reporting areas that they feel compelled to, deal with it in a way that, shows to people looking over their shoulder that they are taking their responsibilities. Continuing priorities are, in the following headings: master sub-accounts. The baseball season just started, and when I went back and looked at OC's guidance on masters and sub-accounts from September 2011, the areas listed in that guidance as being possibly impacted by master sub-accounts included anti-money laundering, insider trading, manipulation, account intrusion, information security, unregistered broker-dealer activity, excessive lending, and day trading. So I don't think there's a whole lot new in this area. Have differing interests. It ties in through a lot of different rules that the SEC is concerned about. Much of this is involved in implementing Rule 15c3.5. Tech, they say tech is a top priority, and again, quoting from their release, events have raised questions as to the effectiveness that are acting counter to expectations and the robustness of firms' risk management procedures. I think this is an area that's really important, especially if you have algorithmic or program or high-frequency trading that is susceptible to and vigorously tested before any change. That's another thing. If there's more freedom by on the part of traders to alter and change parameters and functionality, then I think you have more problems in this. And they're getting involved in technology is more important than ever. Under proprietary trading, they're looking at the capital thresholds under 15C of capital thresholds. In terms of ETFs, they're looking at that in terms of regulation show, fails to deliver, and recommendations that customers buy or use.
Stated priorities for 2013. So one of the ways we look at this is by looking backward at 2012. I know Richard always gets excited when the calendar turns, so we can start putting the various cases that we see in.
Slide 17 is basically the kind of details that FINRA pulls together for you. You can tell that they issued 1,541 actions, $68 million in fines, $34 million you a baseline, and you can see some trends that the number of actions are up, the amount of fines and restitution is up, but it doesn't tell you sort of what areas they're looking at, and they don't break that out. Brad Bennett quarterback throwing the bomb to the wide receiver. It's the blocking and tackling on the line, and that taking care of some of these individuals that need to be barred or suspended for egregious conduct is what they're all about. So breaking down, sort of looking at it on an investigation or rules. So there were 312 different member firms that were sanctioned in 2012, and 60 firms were disciplined more than once. Now, the core, the most common by far sanction involved supervision, failure to supervise or failure to implement or adopt written supervisory procedures. Biggest fear is that they're going to take a reputational hit and from a large settlement and get a press release, and almost all of those press releases dealt with customer harm. So their stated priority of dealing with fines of $1 million or more, which seem to be on the rise. So as I sort of go through the cases that they brought in 2012, 24% of the cases they brought against execution or excessive compensation or supervision of these areas. Now, it's not only 24%, but this is by far the larger fines in terms of dollar amounts are in this area. The next bucket that I would say, these are the cases surprise every year is the leading violation in terms of numbers of cases. Bond reporting in TRACE or RTRS, lots of cases in that area. Equity trade reporting and short sales, short interest reporting. It's one of those areas where firms make a mistake, and that mistake sometimes lasts for 5 or 6 years, and then by the time it's caught, the numbers are huge, and FINRA determines that a large fine is important. So that's one of those areas where it makes sense to every year or so customer complaints round out this topic area. Old favorites, email retention, books and records, anti-money laundering, and suspicious activity reporting, and responses to FINRA inquiries. These made up 14% of cases against firms. The email trips up firms of all sizes. The anti-money laundering also generates some large fines. One of the things I would point out about some of these things is that, problems in responses to FINRA inquiries and email retention or the SEC. I've had clients who felt that years after dealing with an 8210 issue that FINRA was still sort of looking at them suspiciously. So these are areas that it's important to get ahead of and make sure they're dealt with properly.
Form. That code is OV as in Victor, M as in Mary, the number 3, V as in Victor. That's OVM3V. And back to you, Richard.
As we come to the end of the program, we want to turn to some practical guidance that may find helpful. Tune up your procedures dealing with automated systems and this kill switch functionality. You may have that need to know that. I think that that's sort of low-hanging fruit for the regulators to say, there was no widely understood method for shutting down an automated system. On complex products, check your suitability monitoring in terms of all are being distributed to and used by the sales force, and do they need to be updated, and look at them through the eyes of a suspicious regulator who's looking at them in terms of suitability, supervision, and disclosure. Responding to inquiries. People to hear about.
Right, and the inquiries come in all shapes and sizes. You have your routine exams, and then you have for-cause examinations that may come from time to time, and then you have more pointed inquiries. And the perception is that they may be going down the road of moving toward an enforcement action. And this is long before you'll get a Wells notice or anything like that. The staff would be asking questions. And what we found in at least one recent case was that particular situation, the staff really didn't understand. It was a high-frequency trading situation. The staff didn't really understand the firm's business model, didn't really understand what the firm was trying to do with its trading. And we decided the questions being asked and save the advocacy for later. And we decided to put the advocacy up front. We took a routine first request and we made it into more of a Wells response. We anticipated where we thought the staff might be going. Was somehow harmful. What it did was it narrowed the issues down to where the case really should have been, which was looking at procedures and systems and supervision. Hopefully, we've satisfied the staff that be fully familiar with that. Oftentimes the firm and the firm's counsel is, many times more knowledgeable than the staff is about what's going on. Maybe it is time to rethink the old thinking of how you respond to these inquiries, and in the appropriate case, conclusion that you want to get to.
Yeah, and in that one case, the initial inquiry letter was a lot like initial inquiry letters that you get all the time. It said, tell us about this, and there were 20. We think it may be fraudulent. And when I first read that, I thought, whatever happened to sort of, having an open mind till you're done with the investigation? But then, I came to think, well, this is a nice to know where they're coming from so that we can sort of battle it up front, because, the firm's business model and some of the things that they had in place really made, that sort of preliminary background and context than they had asked for, and I think it made it much easier for us to narrow the focus and get this to a much better place than where it started. The last sort of practical point I will talk about is remediation to avoid an undertaking. In many cases, FINRA in more widespread problems, they may require an undertaking to hire an independent consultant. One thing that, if you get to the point, at some point during the investigation where it seems take care of that while the investigation is still going on. Document that and bring it to the staff's attention early on in the process, and that can really help change the firm just doesn't get why they're why this is a problem. Remediation, whether that be new procedures or restitution to customers or bringing on more people, whatever, can 'll see it in terms of undertaking. We have sort of a sub-bullet point here of self-reporting. That used to be, and I think it's still very important, but with, my experience as a regulator, and you should sort of understand this going in, is that firms expected, we self-reported this, they expected, sort of big dividends. They felt that would, should be, go a long way to not bringing a case 50% off of a fine and come back to the firm and say, thank you for self-reporting, here's your $1 million fine. And the regulators felt they were being very magnanimous, and the member firm was thinking, giving credit for it, but it is not nearly the kind of credit that the firms are expecting. That's all I have. Joe, do you have any more to add?
No, I just encourage people to for 10 or more minutes to answer any questions anyone has. Many of these issues could easily be expanded into their own topics of self-reporting and deserve careful consideration. We could talk about that a lot. Well, Richard, actually, I do have one question that just
while we're waiting for other
All right. Thank you, Katie.
All right, great. Yeah, somebody that I know just emailed me here and supposed to
I'm sorry, Joe. A question came in on the thing. I was trying to read it while you were reading the question you had.
Okay.
So I'm sorry.
All right.
Well, the rule is actually broader than just sponsored access or your own access to the exchanges to do trading. You are subject to the same requirements to make sure that you generated by the system and submitted to the exchanges or market centers comply with the regulatory requirements, the SEC and the SROs. So
is, can we speak to this topics with respect to order routing and choosing execution venues? So this is Richard, where they're sending orders meets best execution responsibilities.
Well, I mean, I think order routing and choosing opportunity to receive the best price reasonably available in the market. But now, it turns out that you may need to make sure that your connectivity with all those exchanges is working as you expected it to work. That so I hope that answered the question. If I've
The
missed
follow-up,
it,
the follow-up to that is as it relates to conflicts of interest. So there's is possibly conflicted either by some economic or other incentive that you're receiving back in exchange, or perhaps because of some affiliated status that market center and you may have.
and OC have been talking about where, are you putting your interest in getting a rebate or your, proprietary interest in some their orders. So, that's where the conflict of interest analysis that people have been calling for several years, since Stephen Cutler's famous speech, comes into play as you apply it to order routing and execution.
And again, I think as long as you have a system and a procedure where you're looking at your various to that scrutiny. So I don't think you need to step out just because you're potentially going to get a rebate. It still may be the best price.
Wrap this up, but my email address is on the screen there, or my phone number. If you have particular follow-up questions, love to hear from you. And thank you very much for.
All right, thank you all for participating, and this concludes the presentation. You may now disconnect.